you're all waiting for the full judgment and the reasoning of the Supreme Court. It is out now. What does the NDC think?
There are three issues within that judgment that is mind-boggling. One, for the Supreme Court to say that allegiance is the same thing as citizenship is something I'm worried about. I am a Ghanaian. At any time, I can decide to show, not to show allegiance to Ghana. So, for instance, if I go and pitch camp with Al Qaeda to wage war against Ghana, clearly it means that I have withdrawn my allegiance to Ghana. That's why I'm doing that. That act alone is enough. But my citizenship still remains as a Ghanaian. Let me not go far. Those who win green card to the US, they go to join the American army. They swear an oath of allegiance. That doesn't make them citizens of America. So with these two examples, it is clear to you that citizenship is not the same thing as allegiance. So why should the Supreme Court say that? Why did the Supreme Court come to that conclusion? That's one. Two, in the judgment, the Supreme Court made an emphatic statement that anybody who has dual citizenship and is minded to contest as a member of parliament must show his certificate of renunciation from the other country. Now, there are two types of countries whose denunciation of citizenship is different from the other. One, there are those who, by the mere fact that you've put in an application for renunciation, the renunciation becomes automatic from that day. And they don't give you a certificate of renunciation. So you will never get a certificate of renunciation from them. The mere fact that you put in the application leads to automatic renunciation. And there are those who you have to wait for a renunciation certificate. So what this ruling effectively does is that people coming from the first type of countries cannot contest in our elections. And that was the case that was the situation in the Jomoro case, where they alleged that he had an Ivorian certificate. And we had to bring an Ivorian citizenship, and we had to bring an Ivorian lawyer to testify. And he rightly told the court that the mere fact of putting in an application is enough to renounce. So that's two. The third one has to do with why, and more important, why the Supreme Court failed to address Section 20 of the People's Representation Act, PNDC Law 284, which says that a person is qualified at the time of election. Why did the Supreme Court neglect to deal with that provision? And even if it had dealt with that provision and only come out to say that, well, we have looked at Section 20 of the PNDC law, we think that it's not applicable in this case, and we still think that the time for renunciation is the time of nomination. So there are a lot of loopholes and questions to ask about this judgment.
So let me start from the bottom, and I want to explain the last part for me a bit more. You're saying once the person files and it's clear, the person is qualified.
Which one are you asking?
The one about Section 20.
No, Section 20. You see, the matter in court, you need to get it. The matter in court from the High Court through to appeals to the Supreme Court is that the NPP claimed that James Jechi Question should have been qualified at the time of nominations, which is 5th to 9th October 2020. And we are saying that, and they are hinging their stance on the Nato case. And we are saying that the time for a person to be qualified to contest as a member of parliament is at the time of election. And this is supported by Section 20 of PNDC Law 284, People's Representation Act. So these are two sides of the argument.
So at the time of the election, you believe is that issue that should have been addressed, that the qualification becomes relevant at the time of election, not nomination.
In our case, you notice that James Judgement got his certificate in November 2020 before we went for the elections on 7th December 2020. So if they had averted their minds to Section 20 of the PNDC law, he's qualified. Because before 7th December, which is the time of election, he had received his nomination in November. Are you following?
Yes. And I think that's a disagreement between you and the Supreme Court. The Supreme Court is talking about 9th October as the relevant date. You are saying...
Exactly. So I am saying this, that when we averted their mind to PNDC Law 284, Section 20, my question to them now is, why didn't they analyze it in their judgment, deal with it, and say that, nonetheless, having done that, nonetheless, we still think that, why did they dodge, in other words, why did they dodge the issue of Section 20 of the PNDC law? Because if they have dealt with it, they would have averted their minds to it and they would have realized that the man is qualified. Am I making sense?
Yes, but they were using the Zenator matter.
And I'm saying that the Zenator matter in law will say it's per incuriam, because in the Zenator matter, the Supreme Court's mind was not averted to Section 20 of the PNDC law.
Okay.
Their attention was not drawn to it. So Zenator is even wrong.
Okay. Oh, I get that point now.
You get that point? Because
yes.
in Zenator, nobody averted their mind to it. And the Supreme Court too didn't avert their mind to it. But in this case, lawyers for Kwesi Jackson, James Kwesi Jackson, what's the name?
Jechi Kwesi.
In their submissions, drew the Supreme Court attention that look at this, look this way. You are looking at one side, but look at this one. So the question now is, when we drew the Supreme Court attention to Section 20, why did they analyze it in the judgment? And that's why I'm saying that they could have done that, and if they still wanted to say Zenator, then they'll say that nonetheless, we think that it is still Zenator. I don't know whether you are following me.
I get that part. Then you're also saying that I read the relevant portion, the concluding part. So it's hinged on a certificate being issued. You are also raising the question of there are places where they do not issue certificates.
That's the second point. If you are satisfied with the first one, we can move to the second one.
Yes, I understand that. I understand that point.
So
it's
let's
clear
move
enough.
to the second one.
Yes. So you are saying that the judgment is not relevant to other places where they do not issue certificate.
The judgment has not taken into consideration where in some places, like in Ivory Coast, and in the case of Joe Moro, where we won that case in court because we brought in an expert witness from Ivory Coast who said that for Ivory Coast, immediately you put in the application, it triggers renunciation. And so you don't need to wait for certificate. And you see, you are renouncing that country's citizenship. It's not Ghana's citizenship you are renouncing. So you must take into cognizance their laws, what they say. Now, the Supreme Court says you must bring a certificate. Have you read that part?
Yes. But in the case of James Kwesi, they gave him a certificate, didn't they?
No,
Ultimately.
you don't understand. This judgment is going to bind all of us till their kingdom come, unless it's a change. And I'm saying that, forget about Kwesi. In future, if somebody comes from Ivory Coast, this judgment is effectively stopping that person from contesting. That's the analysis I'm making.
Okay. Okay.
I'm broadening the discussion.
Okay. So you are expecting a judgment that takes into consideration all the possibilities.
Or the judgment that will also consider that. Because now, what it is saying is that the judgment is saying that the EC should now be asking for people's certificates before they register them or they allow them to do the nomination. That's what the judgment is saying. So if I'm coming from Ivory Coast, how do I get that certificate for the EC? What have you done to those of us who are from countries where merely just applying is enough to renounce their citizenship?
Okay.
I'm not talking about just in this case. It's not about James Question. No, it's not about him. It's about the judgment. I'm now critiquing the judgment.
Okay. I get that part too. Then the very first thing you said was the equation of allegiance to citizenship. Exactly. Now, I'm reading to you a portion. No, okay, that will be long. They use the British example, where, for example, they says in order for in Schedule 5, I'm now reading to the 1981 Act that's amended, the form of citizenship, oath, and pledge for registration of or naturalization as a British citizen is as follows. Oath. I, your name, swear by Almighty God that on becoming a British citizen, I will be faithful and bear true allegiance to Her Majesty the Queen Elizabeth II, her heirs and successors according to law. So they are saying that in making that declaration, even though you are taking up a citizenship, you have sworn allegiance to the British monarch.
But when you see the Constitution, Article 94, it will tell you that you must be a citizen of Ghana to contest. And then it comes to 94(2), says that you must not owe allegiance to another country. The framers of the Constitution, those who wrote the Constitution, if they intended that the two are the same, they will use the same words. They will use citizen there, up there, and use citizen down here. The fact that the framers of the Constitution, who were wide awake and were not sleeping, used citizen up, but when it came to qualification, say allegiance, meant that in their mind, they separated the two. Is it difficult to repeat citizen? Is it a difficult word to use?
Ghana's gold.
So if they intended it to be like what the Supreme Court said, they would have used the same words. Either repeat allegiance, or repeat citizen. They intended it to mean different words or to apply to different situations.
Radio gold.
So to you, they should have looked at it in two different perspectives.
It is, even in Rawlings' case, Olsen and Rawlings, I think so, this matter was raised. And they sought to say that once the Fly Lieutenant Rawlings was then in the military and gave his life to the Ghana Armed Forces, he has paid allegiance to the state. And so he's entitled to contest. And so in that case, allegiance was distinctly dealt with from citizenship.
These are three critical issues that you've raised.
Very critical, and I need answers to them.
Okay. That come from the basis of...
I'll give you my example.
Okay.
The United Nations says that there cannot be a stateless, nobody can be stateless. So, nobody can deprive me of my Ghanaian nationality. But I can decide to take my allegiance away from Ghana by doing what? By leaking secrets to other countries. By doing what? By waging war against Ghana. Go and add up to some miscreants to wage war against Ghana. By so doing, I decided to withdraw my allegiance to Ghana. But you can never take away my citizenship. So there's a difference between citizenship and allegiance at all times. It's established.
And I was going to draw attention to the fact that these are grounds for seeking a review. Three main issues.
So what we have done, as at last Friday before this judgment came, you know the rules require that if you want to review a Supreme Court decision, you have 30 days within which to do that from the date of the judgment. But you notice that you cannot also do an effective review unless you see the reasons assigned. Normally, the judgment and the reasons come on the same day, and your 30 days starts running. But because the reasons didn't come, and the reasons ate into the 30 days, we still want our full 30 days. So we've applied for extension of time so that we can have a full complement of our 30 days, so that we can effectively analyze the ruling, and then if there's a need for review, we'll do a review.
And I understand from one of the lawyers in the case that has been set for 22nd.
That's it.
Okay. You go and argue that, and you intend to seek a review if you are granted the permission.
Seeking for review is to go and argue that. There's reasons why we are going for review is to go and have the days, the full complement of the days of 30 days given to us.
And that is even considering the fact that you are still in a scene of contesting an election.
Oh yeah, it can go on. Mm. If we then decide to truncate, we decide. But now, politicians can be on the ground. We are lawyers. We are working in the court.
But I also want to take your view on this before before you leave me. I read this and I don't know. You are the lawyer, so please explain this to me. It says, again, the ratio and facts of the suit are similar to the dispute situation in the case of Sumaila Bilbil versus Dramani and Another, 2011, in which this court recognized its jurisdiction to settle questions relating to the qualification and eligibility criteria for members of parliament under Article 94(2)A. Regrettably, the Bilbil case, which is on all fours with the current case, was never discussed by the parties in this case, apart from cursory reference to it by the counsel for the plaintiff and the third defendant. The similarity of the facts in that case to the present one is evident from the facts and the decisions of the case. I've heard people say they are not similar, but is that not the court saying the facts are virtually similar?
You see, let's make it clear. The Supreme Court are human beings there. They can also get it wrong. So those who just think that once the Supreme Court speaks, it's final. So are they saying that today, if the Supreme Court comes on and say that a certain man you call your father is not your father, when there's no DNA, you take it lying down? Have you got my simple example of why I think that people shouldn't think that what the Supreme Court says is final?
Okay.
So if the Supreme Court today comes on and say that the person I call my father is not my father, when there's no DNA taken, just looking at our faces, say it's not your father, will you sit down and say, oh, the Supreme Court has spoken, so I agree? Those are the type of things we are talking about. Okay. Biela and this one, it's not the same. In fact, in Biel, Adamu Sekande, when he picked the nomination form, did not put in an application to renounce. When time of elections, he didn't renounce. When he was sitting in parliament, he didn't renounce. It was only when he got wind that there's going to be an action against him that he then put an application in the Home Office of the UK. So why would the Supreme Court is all on force? Can't they look at the conduct of the persons involved? Somebody who put in an application to renounce in November 2019. This is the government that says that COVID has come to do what and what and blaming everything on COVID. Because of COVID, and don't forget that COVID started in the outside world around November of 2019. You remember, we got ours in March 2020. So by November, offices were closed down. And that's how come you didn't get it early. And you want to compare a person whose intentions are very clear, outrightly clear. A person who expressed his intentions so loudly in November 2019 to somebody who, when he was sitting in Parliament representing the people of Boko, had committed a crime. You want to compare the two?
From listening to the facts that have been put out, shouldn't this have been a matter that should have been tried at the High Court properly? And
that is the problem. I was at the High Court representing Kwesi. And I told the judge that there must be a hearing on this matter. So that at least when the man goes into the witness box, he will know that the rules of natural justice have been played out. You have heard from him before you say, no, he can't be a member of Parliament. The judge said no. That for him, there's no need to take evidence. We should write our written submissions and he will give judgment. It was one of the reasons why I said that this judge was not fair. You know, at the point in time, I told the judge to recuse himself.
Yes.
And when he didn't, I recused myself. Because I'm principled. So this, you are right. There must be, there should have been evidence. But we are talking about foreign law. And foreign law, we all know, every law student know, it's a matter of fact. And being a matter of fact, you must lead evidence. And the evidence must come from an expert witness, somebody who knows about that law. You are trained as a lawyer and a judge in Ghana law. You are not trained as a lawyer and a judge in Canadian law. So you can't purport to be sitting in Ghana and be dealing with Canadian law. So you needed evidence to aid you to make your judgment. These are some of the things. So you're right.
Okay. Well, thank you very much for speaking to us this morning.
Thank you, Bob.
Yeah. That is lawyer Abraham Amaliba. He is Director of Legal Affairs of the National Democratic Congress. Join us this morning to speak about the judgment in the case of James Kwesi.